Hello, this webinar is a part of the U.S. Constitutional System series, and it's an example of a state Supreme Court resisting the U.S. Supreme Court. Now, we have a webinar on the resisting of the accumulation of power. This is the right and duty of the lower civil ruler to stand up to a higher civil ruler when the higher ruler is exercising powers not granted to them. And we have a whole webinar that explores that. This webinar uses an example of a state Supreme Court. First, by way of background, this is what a state Supreme Court system looks like when you're looking at a beautifully diverse map of the United States of America, where each state has a capital, they have a governor, they have a legislative branch, and they have a state Supreme Court. What a beautiful map of 50 self-governing republics with state constitutions, with citizens within those states practicing self-government at a local level. This truly is the beauty of the American constitutional system. Now, each of these states surrendered just a little bit of their power to the national government when they set up the U.S. Constitution. And in that U.S. Constitution, a Supreme Court was established, as well as district courts, and currently there's 11 of them. It's through these district courts that the federal court system works, and the district courts feed into the Supreme Court, or they are under the care of the United States Supreme Court. They're a part of the U.S. Supreme Court system, if you will, or the federal system of courts. The federal court system was assigned just a few responsibilities initially: to interpret the laws passed by Congress when needed for special situations, and to settle disputes between two or more states, between citizens of different states, or between states or citizens in foreign states, or if the citizens and states had issues with the federal government. This federal system is what Thomas Jefferson was wary of. He said this: the germ of dissolution of our federal government is in the federal judiciary, this very thing we are looking at. An irresponsible body, for impeachment is scarcely a scarecrow, working like gravity by night and by day, gaining a little today and a little tomorrow, and advancing its noiseless step like a thief over the field of jurisdiction until all shall be usurped from the states. This is in fact what has happened. The Supreme Court through the federal court system has always been accumulating power. But in the 1950s and 1960s, the Supreme Court began to aggressively expand its power. So in this webinar, we're going to take a look at how one state Supreme Court, the Utah Supreme Court, resisted the expansion and usurpation of power by the Supreme Court and the federal court system. Here's that case. It was in 1968, the case of Diet versus Turner. In this case, the plaintiff, Mr. Diet, was confined to a state prison in Utah as a result of a guilty plea entered on a charge of issuing a check against insufficient funds with intent to defraud. Well, the Utah Supreme Court had seen the U.S. Supreme Court's actions and was fearful that the federal court system and U.S. Supreme Court was going to involve themselves in this affair. And they said this: we feel that our decision in this matter should not be subject to reversal by inferior courts of the federal system. However, it's rather obvious that such a proceeding is likely to occur unless we turn the prisoner loose upon society. We deplore such a situation as now foisted upon the states by various rulings of the United States Supreme Court. Well, they said this in the opening paragraphs of the case, but then they really got busy in writing the commentary on what the U.S. Supreme Court was doing and their feelings on it. I'll read through this commentary without comment so you can get the force of their reasoning. The United States Supreme Court, as presently constituted, has departed from the Constitution as it has been interpreted from its inception, and has followed the urgings of social reformers in foisting upon this nation laws which even Congress could not constitutionally pass. It has amended the Constitution in a manner unknown to the document itself. While it takes a 3/4 vote of the states of the Union to change the Constitution legally, yet as few as 5 men who have never been elected to office can by judicial fiat accomplish a change just as radical as could 3/4 of the states of this nation as a result of recent holdings of that court. The sovereignty of the states is practically abolished, and the erstwhile free and independent states are now in effect and purpose closely supervised units in the federal system. We do not believe that justices of once free and independent states should surrender their constitutional powers without being heard from. We would betray the trust of our people if we sat supinely by and permit the great bulk of our powers to be taken over by the federal courts without at least stating reasons as to why it should not be so. By attempting to save the dual relationship that has heretofore existed between state and federal authority, and which is clearly set out in the Constitution, we think we act in the best interest of our country. We feel like galley slaves chained to the oars by a power from which we cannot free ourselves, but like the galley slaves of old, we think we must cry out when we can see the boat heading into the maelstrom directly ahead of us. And by doing so, we hope the master of the craft will heed the call and avert the dangers which confront us all. But by raising our voices in protest, we, like the galley slaves of old, expect to be lashed for doing so. We are confident that we will not be struck by 90% of the people of this nation who long for the days when the Constitution was a document plain enough to be understood by all who read it, the meaning of which was set firmly like a jewel in the matrix of common sense and judicial decisions. When we bare our backs to receive the verbal lashes, we will try to be brave, and should the great court of these United States decide in our thinking we have been in error, then indeed we shall feel honored, for then we will then be placed on equal footing with all those great justices who at this late date also have been said to be in error for so many years. The federal courts have arrogated unto themselves the powers and duties which rightfully belong to the state courts. Well, the Utah Supreme Court was pressing back against the overreach of the federal court system and the U.S. Supreme Court. Toward the end of that commentary, it was saying also that there was many other state courts that were also saying the same thing. This was the American constitutional system and how it was designed to work. And it harkens back to a great quote from the Declaration of Independence, buried in the list of grievances, where the Declaration says this, that legislatures and governors opposed with manly firmness the invasions on the rights of the people. I hope this example inspires you and gives you something to think about. My name's Craig Seibert. Thanks for listening.